Yes.
I just wanted to say something funny. I caught myself laughing at your video this weekend, and I was like, wow, I got my TV connected to YouTube, so I'm like laying on the couch watching your lectures, and I kind of like started to doze off a little bit. And then when I opened my eyes, you were like coming to shut the camera off, and you're like, it's like you were looking at me. I kind of started laughing, like, oh man, I got caught.
Like what's going on here?
I'm always watching.
Big brother.
Always watching. Know all and see all. Okay, chapter 9. Chapter 9 is one of those chapters that I think people love to hate. It is definitely one that is heavily tested because obviously dealing with contracts is a super important part of what we do as real estate brokers. We don't write contracts. We do help our clients put together offers, and we help our clients evaluate offers. So we need to have some idea of what's involved with a contract. When we talk about contracts, there's often a ton of confusion about what they actually are. Let me be clear about something, folks. A contract is never required to accomplish a deal. There is no requirement that you have a contract to get from point A to point B. As a matter of fact, life would be a heck of a lot simpler if we didn't have contracts. Because in a world where there were no contracts, we would be in a world where we could always trust people to do what they have promised to do. One of the biggest mistakes people make on an exam is making the assumption that if something's wrong with the contract, we can't close, or the transaction can't move forward. Of course we can close, because the truth is a contract was never required in the first place. Why do we have contracts? It's not so we can make promises to each other. So why do we have contracts? If the contract isn't the promise, what is it? There it is. That is the perfect answer. It's the ability to enforce the promise. And where would that enforcement happen? In a court of law. That's what a contract is. People make promises to each other all day, every day. And they can decide on their own whether or not to fulfill those promises. Here's what I will tell you. I have been involved in thousands of real estate transactions. The actual contract, the number of times that I have had to go back to that contract, pull it out, hold it in front of somebody's face and said, no, this is what you promised to do, I can count on one hand. That's how meaningless these things are in 99% of your transactions. But we don't write contracts for the 99% of transactions where people do what they promise to do. Why do we have a contract? For when people what? Don't do what they promise to do. The idea of a contract is to take that set of promises that these two people have made to each other and do what is necessary to make those promises legally enforceable. Is everybody with me on that? To make them legally enforceable. That's the idea of a contract. Now here it says between legally competent parties. We're going to talk about what that means as well. Because you can't have a legally enforceable agreement, meaning a court of law would never enforce it if the court of law didn't feel that the two parties had the ability to make those promises to each other in the first place. So not only do we have to understand what the promises are and what the court would do about the promises, we have to understand what the court's rules are for making sure that the two parties can actually engage in those promises. Everybody with me on the idea of a contract, okay? So contracts should be voluntary. You cannot force someone into a contract. That's just not something that we're going to do. It's not what contracts are for. Remember, we said a contract is not a set of promises. It's the ability to legally enforce those promises. What do you think would happen if you ended up with a contract in court and one of the two parties said, I was forced against my will to enter into this agreement? What do you think the court's going to do with that agreement? It's going to throw it out. It's going to say you didn't have an agreement. You didn't have a legally enforceable agreement because one of you never agreed in the first place. So So one of the first things you have to show in order to prove, and this word enforceable, I'm going to probably say it 1,000 times over the next 2 hours, because that's the only thing that matters when it comes to contract law, is this idea of enforceability. Would a court of law look at this set of promises and make the two parties do what they promised to do? That's what enforceability means. And if it's not voluntary, they would not. Yes, ma'am?
Does this include coercion?
Does this include coercion? Yeah, we don't call it coercion. That's not the legal name for it. But we have actually two names for somebody being coerced. Either duress or undue influence. There are two ways that somebody can be forced or coerced into an agreement. Duress is the threat of physical harm. So if somebody were held at knife point and forced to agree, that would be called duress. They agreed under duress. If somebody were basically held hostage by their own emotions, you know, Mama, I am never coming to see you again if you don't sell the farm.
Right.
That's using an emotional connection to exert influence over somebody. We call that undue influence. They're both a form of coercion. And in either case, if you showed in a court of law that either of those was present, a judge would throw that agreement out and say this is not a voluntary agreement, that the parties were not voluntarily agreeing to be bound by these terms. So that's a really good question. Everybody good on that? Okay. All right. The other thing that we have to have is something called a meeting of the minds, or an agreement of the terms. If you're going to go to court, and remember, contracts only matter in court, because the whole key to a contract is, would a court of law do what? Would it enforce the agreement? That's the key here. Would the court of law enforce the agreement? So you have to be able to show that both parties agreed to the terms of this thing. That both parties said, this is what we want to do. This is what we've promised to each other. So we're going to talk about later on, like when we get to sales contracts, we're going to talk about this idea of offer and acceptance. Offer and acceptance is this process of having meeting of the minds. Someone makes an offer and the other party has to do what with it? Accept it. When you can prove offer and acceptance, you've proved that you have this meeting of the minds, that the two parties have agreed on what they're promising to one another here. So let's talk about what legally competent means, because it was said it's an enforceable set of promises between legally competent parties. So let's talk about what legally competent means, what it is and what it's not. In order to be considered legally competent in North Carolina, the parties, first of all, have to be adults. You can't be a minor and be held responsible for a contractual promise. Now, let me back up here, because this is where I have to start to go back and retread what I've already said. Can a minor promise to do something? Of course they can. There's no question that a minor can make a promise. Can they be legally held to that promise by a court of law? No. And that's the differentiation. Does everybody understand that? So when I say a minor can't be held responsible for a sales contract, that means if a 17-year-old, because we define minors as anybody who hasn't reached the age of 18 in North Carolina, if a 17-year-old walks into a new home construction site and signs a contract to purchase one of those homes, can that 17-year-old purchase one of those homes? Yes, they can. What they can't be is held responsible for the promise to purchase one of those homes. That's all well and good as long as they follow through with their promise. But what good is that agreement that they signed if they decide not to follow through with it? It's not worth the paper it's written on. Does that make sense to everybody? Because a court of law is not going to hold them responsible for that promise because they don't meet the definition of legal competency. Everybody following me on that? So you've got to be an adult. You've got to be mentally competent. I really hate this one because there are a lot of people that I feel are not up to this level who still, according to the law, meet this definition. So we'll say You have to be legally competent according to a court of law in North Carolina. That's a pretty low bar, trust me. If you get out there in society, you'll realize that some of them are interesting. But basically, you can't have somebody who's been declared mentally incompetent, for whatever reason. Maybe they have some sort of senility or dementia, or maybe they just have, they're emotionally disturbed and they've been declared mentally incompetent. They've been appointed a guardian. Those types of people cannot be held responsible for contracts. And not intoxicated. Yes, ma'am.
What about veterans with like service animals, post-traumatic stress, things of that nature? I mean, I know that they buy homes. Is that
they have not been adjudicated as mentally incompetent. They still have legal control over their decision making. So when we say mentally competent, or better yet, to say mentally incompetent means that at some point in time a court of law has taken up the issue of their mental stability and judged this person cannot make their own decisions. So it's a pretty extensive process to get to that point.
okay?
Somebody's been appointed, yeah. Yeah, right. Once they declare you mentally incompetent, they have to appoint a guardian, because essentially, if you've been declared mentally incompetent, the court is saying you can't be held responsible for your own actions, so somebody else has to take responsibility.
So when we talked about handicap issues or things of that nature, you stated that we're not allowed to ask a lot of things surrounding that we just can ask supportive questions. Is this the same?
Yeah, see, it's an interesting question. Realistically, I don't know if there are any laws that govern what you could or could not ask to determine somebody's mental competence. I would probably suggest staying away from it. And simply, here's the reason why. So few people are ever declared mentally incompetent. I mean, it is a very long and arduous process to get somebody to the point of being declared mentally incompetent, that the odds of you encountering such a person in a transaction are astronomically low. So it certainly would not be worth the risk of infuriating somebody else by basically asking, has a judge ever declared you mentally incompetent? Because that probably would not go well at that point in time. I have seen it one time in my career, and it didn't involve me personally, thank God. Years ago when I first got into business, I was at Remax 20 Edge in Chapel Hill, and a gentleman came into the office one afternoon, and one of the agents who was sitting at the front desk introduced herself, and he said he was wondering if anybody could show him a house that was for sale on Franklin Street, and of course she said she'd be glad to, and he went and looked at the house, and he loved it, and he wanted to make an offer on it, and he had his checkbook with him, and he wrote a check for an earnest money deposit. He signed a buyer agency agreement. They made an offer on the property. The offer was accepted, and 2 days later, a significantly younger lady came into the office and asked to speak to whoever was in charge, and the broker in charge went out and met with her, and she introduced herself, and she said, I believe my dad was in here earlier in the week, and he has Alzheimer's, and he has just moved here from New York. He was in the real estate business up there, and it's come to my attention that earlier in the week, when I thought he was just out going for a walk around the neighborhood, he may have come in here and bought a house. Yeah, basically. What she found was his old checkbook, and she saw the check that had been written to our firm for the earnest money deposit. She kind of put two and two together. She lived right down the street from the firm, and it turned out he had been declared mentally incompetent. She was his guardian, so that contract just evaporated. That's the one time in my career I've ever actually encountered somebody like that. I would never ask. I just wouldn't. I would say that the odds are so low of that becoming an issue that it's just not worth even trying to ferret it out.
There's so much legally binding stuff around so many gray area things.
Yes, for sure. Yes, sir.
Can I get that set of slides? This seems missing.
Chapter 8.
9.
9.
9 and 8 to 10.
Yeah.
Oh, never mind. Strike that.
Got him?
Yeah, it was
And then the last one is not intoxicated. Now I will tell you, this is one that you do have some control over. Ultimately, you can't judge if somebody's intoxicated. Nobody expects you to have a breathalyzer or some blood alcohol test or that sort of thing with you. However, you can certainly control whether somebody is consuming an intoxicating substance in your presence while you're doing something like presenting an offer to them. If you have a seller and you're presenting an offer on their house and they're having their evening cocktail, it would probably be a good idea to ask them to do what? Let's refrain from doing that. Let me present the offer, and once we decide what we're going to do, I'll be glad to have a drink with you. But I need you perfectly clear-headed, because if there was ever any insinuation down the road that they were intoxicated, one of the first questions that would be asked of the real estate broker would be, well, did you have any reason to believe they were intoxicated? Well, if you sat there and watched them drink, you don't have much of a leg to stand on. Does that make sense for you guys? I'm not saying you should determine if they're intoxicated. Let a court of law determine that. But I'm saying to protect yourself, if you see that's occurring, the best thing to do is to say, let's just hold off on that. Let's wait. And then we can have a celebratory drink after we've accomplished the business. Fair enough? Okay? Now, this is one of the biggest requirements of contract law and one of the most misunderstood. The requirement that there be something called consideration. Consideration means the exchange of something of value. Now, most often, what is that something of value going to be? Money. It could be anything. It doesn't have to be money, but that is most often what represents consideration in the contract. Now, here's where the confusion comes from. When I say the exchange of something of value, I don't mean that it's already happened. I mean that the contract has to have some promise that something of value will be exchanged. In other words, it's only a legally enforceable promise if you're getting something in return for it. Does that make sense for everybody? Here, let me give you an example of that. Yuchan owns a house. She has decided she is going to give it to me. Awesome. She writes it down. I promise to give Travis my house. She signs it. I sign it. And then she calls me the next week and says, I have changed my mind. I'm not going to give you my house. I don't have any legal recourse to force her to give me that house because there was no promise of the exchange of what? Something of value. What is Yuchan getting out of the deal? Nothing. So she can change her mind anytime she wants to because that's not a legally enforceable promise. Does that make sense? If I were smart, when she said, I'm going to give you my house, I would say, oh no, I insist. I must pay you $1 for it. Because if we signed that agreement, and that agreement said she was going to sell me her house for $1, and she tried to change her mind, would I have legal grounds to stand on? Absolutely, because that is the exchange of something of value. She's bringing something of value to the table, the property, and I am giving her something of value in return for that. Does that make sense for you guys? Now, let me tell you where you're going to go off the reservation and off the rails with this idea. We're going to talk about things like earnest money deposits. What do you think the purpose of an earnest money deposit is in a transaction? To take it off the market, make sure people are serious about buying it, all those things, right? Earnest money is not consideration, folks. Because what you're going to be presented with on a test, you're going to jump right on it. No, you don't have consideration. They're going to say that Travis has agreed to sell his house for $200,000 and Sammy's agreed to pay $200,000 and agreed to pay a $2,000 earnest money deposit, but he has not yet delivered the earnest money. Is this an enforceable contract? What is the answer? Yes. Yes. Because there is the promise of the exchange of something of value. I don't give a rat's fat rear end whether that has happened yet or not. The whole purpose of a contract is to have promises. If the money had already been delivered, there'd be no need for what? For a contract in the first place. Does that make sense? It's not whether money has been delivered, it's that money was what? Promised between the two parties. You see why I say this is confusing for people? The contract has to be supported by consideration. That doesn't mean they have to have already exchanged money. It just means they have to both be promising to exchange something of value. What am I promising to exchange? The property. What is Sammy promising to exchange? The $200,000 purchase price. Could we have, it wouldn't even have mattered if the earnest money had been zero anyway, right? Was there the promise to exchange something of value? Then we have legal consideration, and therefore we have an enforceable agreement. Is that clear for you a little bit? Okay. It's not whether it's already been exchanged, it's that have we promised to exchange it. So basically, another way to say this is, you can't have a contract for $0. If it's for $0, it's not a contract. Because if it's for $0, one party's not providing anything of what? Of value to the transaction. So make it for some amount of money or something of value. Now when I say something of value, could we have an agreement whereby I'm going to trade my car for a piece of land that Bo owns? Would that be supported by legal consideration? Yes, it would. Are both parties bringing something of value to the transaction? Bo's bringing a piece of land, I'm bringing what? The vehicle. So it doesn't have to be money, it most often is. The key here is that something of value has to be promised by both parties. We good with that? That is the key idea to consideration. Okay, good. And a contract must have it, or it is not what? What's our magic word? Enforceable. Not enforceable in a court of law if you don't have that. Another kind of important thing. The thing you're promising to do should probably be for a legal act if you're going to ask a court of law to enforce it. If you're going to go to court and say, Your Honor, they promised to do this, please make them do it, you probably should not be saying, well, they promised to kill this guy and I paid them for it, but they didn't do it. It's not going to go over well for you. Because the thing you're claiming that they promised to do is what? Illegal. And that's not going to be an enforceable agreement either. A court of law is never going to enforce an illegal act. So the thing, the basic promise that's being made between the two parties has to be legal in the first place. People have done dumber things. Somebody in Wilkes County last year tried to sue over a marijuana deal. They filed a small claims action and said they paid their dealer for an ounce and he only sold them a half an ounce. And they filed that in small claims court in Wilkes County. What a moron, right? You know, I tell you what, that agreement's not enforceable, but I know some agreements that probably were enforced that day. I would imagine. Okay? So it has to be for a legal act. Is everybody good on that? That's another major requirement. Contracts can either be express or implied. We already talked about this a little bit with agency agreements. Y'all remember this discussion? We said an agency agreement could be expressed, which meant we had clearly laid out the terms. We said it could be orally expressed or written. What's the best way to have an express agreement? Written. Contracts work the same way. We can have express written contracts or express oral contracts. The key here is that the terms have been clearly expressed. What did we say implied agency was when we were talking about agency agreements? Actions. I don't have the authority. I haven't been given the authority, but I what? I acted like I had it. That's what we said it meant with agency. Well, here's what it means with contracts. I never actually agreed to these terms. We didn't even talk about the terms. But my actions implied that I was willing to abide by them. That sounds crazy, but it's actually how you function on a daily basis. There are things you do every single day that are implied contracts. When was the last time you went out to dinner? How many of you go out to dinner somewhat regularly to like a sit-down restaurant with a server? When you do, and you place your order, does the server say, now you understand that if you order this food, your appetizer is going to be $12.97, your entree is going to be $22.98. If you add all that together, it's whatever that total is, and we're going to add tax, and then you're going to also be expected to pay a gratuity. Does the waiter or waitress explain that to you at the table? No. It's not an express agreement. You have implied that you're willing to do what? To pay for it because you ordered it. Is that an enforceable agreement in a court of law?
Yes.
If you don't believe it, walk out. See what happens. So implied agreements can very much be enforceable. Don't be so closed-minded as to think a court of law will only enforce a written agreement. Not only will they enforce some oral agreements, sometimes they'll enforce implied agreements where you have acted like something, and so therefore you must follow through with it. But for your purposes, as a real estate broker, where should you be always operating on behalf of your clients? What kind of agreements? Express, and not only express, but what kind of express? Written agreements. Because written agreements are very clear about what the expectations are. Everybody good on that difference? Okay. Now, you may on a test see questions about whether some agreement is a bilateral agreement or a unilateral agreement. I remember this by simply thinking of a bicycle and a unicycle. I have a guy who rides a unicycle through my neighborhood. It's the craziest thing I've ever seen in my life. And he walks his dog while he's doing it. Yes, a unicycle. And he walks his dog while he's, I would kill myself and everybody else in the neighborhood if I even attempted anything like that. But it helps to remember. How many wheels does that unicycle have? One. So a unilateral contract. Now, it's one of something, but here's what you got to be careful of. It's not one party. There's no such thing as a contract that only has one party, because a contract is a set of what? Promises made from one party to what? Another party. So a unilateral contract is not a contract that only has one party. It's a contract where only one of the two parties has actually promised anything. Only one side has actually promised to do anything. Let me ask you a question. If a buyer makes an offer to purchase a property, has the seller promised to do anything? No. Has the buyer promised to do anything? Yes. How many parties are there to that contract? No. There's two parties. There's a buyer and a seller. But how many of them have made a promise to do something? One. That is a unilateral contract. Only one side has promised. If the seller were to accept, guess what it would become? A bilateral contract, because now the seller would have promised to do what? To sell the property. Does that make sense for you guys, the difference between the two? It's all about how many sides have promised to do something. Later on in this chapter, we're going to talk about option contracts, or actually it's in chapter 10. We're going to talk about option contracts. Let's talk for a second about an option contract, since we're on this idea of unilateral. Let's say that Catherine is looking at several different pieces of property, 3 to be precise. And she doesn't know, she knows she's only going to buy one. But she hasn't yet decided which one she wants to buy. Is everybody following me on that? Now, she can keep looking and trying to decide, but what risk is she running by doing that? One of the 3 or all of them could do what? Could sell and she won't have the opportunity. So Josh owns one property, Teresa owns one property, and Omar owns another. Everybody with me? Now, Catherine could protect herself. She could protect her ability to take her time. Because she could go to Josh and she could negotiate a purchase price for his property. But she says this, here's the thing though, I'm not really ready to commit to buying your property, but I'll pay you $5,000 to give me 2 weeks to decide. Could Josh accept that? And here's the thing, he gets to keep the $5,000 whether she does what? Whether she buys it or not. They've negotiated the price. They've agreed she's going to buy the property from him for $2,000. $200,000. $200,000. She's going to buy the property from him. But she's going to pay him $5,000 when? Right now. And the only catch is he has to do what for the next 2 weeks? Take it off the market. He can't sell it to anybody else. That for the next 2 weeks, she's the only one who has the right to do what with that property? To purchase it. Can she negotiate the same thing with Teresa? And the same thing with Omar? And if she locked, so she pays Teresa $5,000, she pays Omar $5,000, she negotiates a separate deal with each one of the three. Now she has 2 weeks to do what? Take her time and leisurely decide. Because none of those three sellers has the right to do what? To sell to somebody else. Have the sellers promised to do something to her? Have they made a promise to her? Yes, they will do what? They will sell their property at the price they've agreed to sell it. Does that make sense? That's the promise they've made her. Josh has promised he will sell Catherine his property. Teresa has promised she will sell Catherine her property. Omar has promised she will sell, or he will sell Catherine his property. Does that make sense for everybody? What promise has Catherine made? None. She's made no promise whatsoever. So what kind of agreement does Catherine have with Omar? Unilateral. What kind of agreement does she have with Teresa? Unilateral. What kind of agreement does she have with Josh? Unilateral. They've made promises to her. She's made no promise whatsoever to them because she has 2 weeks to completely decide which way or another she goes. That's called an option. It's her option. Does that make sense? That's a unilateral contract. It's a one-sided promise. Now, obviously, most of the time in real estate, we don't want to operate in unilateral contracts. We want to operate in what kind of? Bilateral contracts, most of the time. A promise for a promise. Now, to use that same example, so Catherine has made her decision. She decides she wants to purchase Teresa's property. She contacts Teresa and she says, I am exercising my option. Now, what kind of agreement do we have? We have a bilateral, because now Catherine has promised to do what? To buy. Teresa's promised to sell, Catherine's promised to buy. Promise on each side, that's a bilateral agreement. Everybody okay with that? Alright, that's the difference between bilateral and unilateral. The difference between executed and executory, these are words that are misused all the time in the real world. A lot of times somebody will send me an email on a transaction and say, can you send me a copy of the executed contract? And I have to resist my temptation to correct them because the teacher in me wants to come out so badly. I would be wasting my time to send them a copy of an executed contract. What would an executed contract be? One that has already what? Closed. We have executed it. It is dead. The promises have been fulfilled. It is closed. It is gone. What they really mean is they want me to send them a copy of the executory contract. Executory means it's been signed and accepted and agreed to, but we haven't yet closed it. We haven't fulfilled the promises. Executed means done. Everything's been concluded. We're finished.
Executory means all things have been
Accomplished. That's right. That's exactly right. We haven't executed on these plans. We've made the plans, but we haven't executed them yet. We have an agreement. That agreement is enforceable, but we have not finished. So, if I was looking at a contract that was just accepted yesterday, am I most likely looking at an executed agreement or an executory agreement? It's an executory agreement. So we call the time period between contract formation, when the two parties agree, and when they close, the executory time period. It's the time it takes to execute the promises. That's the executory period. Everybody all right with that? That differentiation? Because you may see it on the test. It's just a vocabulary thing. And we already talked about this vocabulary word, enforceability. And this is definitely the big word when we talk about contract law. Is the contract enforceable? Meaning, would a court of law honor it? Would a court of law uphold it? Would a court of law look at that agreement and say, you have to follow these promises? That's what enforceability means. Here's the thing though. Don't confuse enforceability with closability. Can any contract be closed?
Yes.
Yes. If the two parties show up and do whatever it is they promised to do, it does not matter whether they had an enforceable agreement or not. As a matter of fact, we'll probably never find out if they had an enforceable agreement, because what's the only way you can find out if a contract is enforceable? Sue. Go to court. Because one of the first things you have to determine when you end up in court is, do we have an enforceable contract? You never know, hopefully, whether you have an enforceable contract or not. Because 99 times out of 100, guess what? We close and nobody ever even pays a second look at what? The contract. Nobody cares whether it's enforceable, because the buyer wants to buy and the seller wants to what? The seller wants to sell. And they both have a pretty dang good idea of what they promised to do, so they what? So they do it. See, that's the thing. If the buyer shows up with money and the seller shows up with the deed, it doesn't matter whether they ever even had a contract, because what are we going to do with it? We're going to close that thing and get paid. When you have two agreeable parties. Ultimately, we spend all this time focused on contract law for when there are disagreements. When they don't agree, when somebody says, that is not what I promised to do. Now what do we need to do? Go look at the what? At the contract. Let's see what you promised to do. And let's hope like hell that this promise is enforceable in a court of law. That's why we spend all this time focused on this thing, is to try to make sure that we are protecting our clients in the best possible way by creating an agreement that will be enforceable if that becomes necessary. You should try like crazy to avoid ever finding out if one of your contracts is enforceable, because you don't want to end up where? In court. There are going to be plenty of times, folks, when you even know you're right. Leslie gave me this expression over the years. She told me years ago, she said, Travis, you can be right or you can be happy, but you can't be both. And it's very true. You can be right or happy, but you can't be both. And contract law is very much like that. There are going to be times in your career when you know that is not what the contract says. But you also know the only way to ultimately find out is to go where? Court. And I'm going to tell you, most of the time everybody loses in court because it's time consuming, it's expensive, it's just unfulfilling, it's just nasty. So there are going to be times when you have to look at your client and go, you know what, they did promise to replace that board on the deck. But you got all your crap in the back of a U-Haul truck. And the only thing you can do right now is not close and file a lawsuit against them. What do you want to do? I would say close. Does that make sense for everybody? And so this enforceability idea is really just there for big disagreements, major disagreements, where the two parties just cannot be brought together for whatever reason. My opinion is your job is to try to avoid that at all costs, because you don't want to be there. I promise you don't. Even if you're on the right side of it, you don't want to be there. It's not going to be fun. Okay? But enforceability is what we're focusing on here. Okay, so everything else we're going to talk about the rest of this chapter has to do with enforceability. This word, valid. Valid. Valid is good. Put a big smiley face on this slide. Because a valid agreement is one that is enforceable on both parties. See, the thing is with a contract, contract's not one-sided. And it's not all or nothing. If you end up in court, you could find out, oh, well, this contract's enforceable on this side, or this contract's enforceable on that side. Hopefully the contract will be enforceable on which side? Both sides. That's valid. A valid contract is one that's enforceable on both sides. One that a judge would look at and say, you promised to do this, you promised to do that. Both of you do it. That's a valid contract. Now, not every contract is going to be valid, unfortunately. Some are what we call voidable. Voidable. Voidable means they can be voided. Does that make sense? Does it mean they are voided? No. Does it mean they go away automatically? No. It means one side can avoid the promise they made. How many sides did I say could avoid the promise they made?
2.
No. One. One side can avoid the promise they made. Which means one side has to do what? Follow the promises. If one side doesn't have to follow it, then the other side must have to. Go back to valid. How many sides have to follow the promises? 2. When you're at voidable, only one side has to follow the promises. It's not valid because one party, for one reason or another, is not obligated to follow the promises. What about the other party? They are obligated. Is that an uncomfortable position to be in? To be involved in a contract where you are bound to do what you promised to do, but the other side is not bound to do what they promised to do. Would that be an uncomfortable position to be in? That is what we have in this picture right here. This is the classic example of a voidable contract. Because what we have here is one party who is legally competent and one party who is not legally who's not legally competent in this picture? Mr. Crayon here, right? The kid is not legally competent. So can he be held to any promises he makes? No. Can the adult be held to any promises that he makes? Absolutely. So if this agreement were signed by both parties, it would be a voidable agreement. Because the one party who's a child is not going to be held responsible for their promises, but the adult would be. So how many parties is that being held responsible? One. Which means there's also one who can do what? Walk away, not do anything, because they haven't legally promised to do anything. They've promised, but they haven't legally promised to do anything. It's not enforceable on that one party, but it is enforceable on what? On the other party. So think about all those things we talked about earlier where we said we had to have legally competent parties. What were some other examples of that? Drunk. One party's drunk. Would that result in a voidable contract? Now let me ask you a question. Who would be bound? The drunk person or the sober person? The person that signed it when they were sober or the person that signed it when they were drunk? Who would be bound?
Sober.
The sober person. Who would not be bound by that promise? The drunk person. Does that make sense for everybody? That is a voidable contract. Now, here's where it gets more complex. And this is where people start to lose their mind when they talk about words like voidable. it could start as valid, but become voidable. What does valid mean? It's enforceable on how many people? Two, both parties. So let's just say that Teresa and Omar have made promises to each other. Teresa has agreed to sell her home to Omar for $200,000. Omar has agreed to pay $200,000. Is that a bilateral or unilateral agreement? Bilateral. Is it enforceable? Is it valid? Because it's enforceable on which parties? Both. Everybody in agreement on that? So we got a valid contract. Now, in addition to paying $200,000 for the property, in addition to selling the property for $200,000, Teresa has agreed that she will replace the steps leading to the deck because they're rotten. That is part of the agreement. Does that make sense for everybody? So is that an enforceable promise?
Yes.
Yes. We get to the day of closing and the deck steps have not been replaced. Now, how many parties made promises? Two. How many have lived up to their promises? One. Omar has not done anything wrong here. Does that make sense for you folks? He has been harmed because Teresa has breached that agreement. She has not fulfilled one of her promises. Does that make sense for you guys? Everybody follow me on that? Who do you think is going to have the right to say, nope, you did not do what you promised, I'm out? Is it going to be Teresa who has that right, or is it going to be Omar who has that right? It's going to be Omar who has that right to say, no way, I'm out of here, you didn't do what you promised to do. So the way we say that legally is that contract is voidable for Omar. It's voidable at his choice because he's the one who gets to decide what? If we close or not. See, Teresa can't intentionally breach and then get the right. Wouldn't it be stupid to say that she's the one that can now decide, oh, no, the contract's been breached, so we don't have to close? Because all that would mean is if she wanted to get out, all she would have to do is what? Is breach. We're not going to let her get away with it. It's him who's been harmed, so it's him who has the right. Who's still bound by the agreement? Teresa is. Her breach doesn't release her from the agreement. It releases who? Omar. Her breach releases him. And since he's been released, he's no longer bound. It's no longer enforceable on him. Voidable means it's only enforceable on how many parties? One. It started as what? Valid. And because Teresa breached, it became what? Voidable. It became voidable.
And it can't become voided.
And that'd be up to him, whatever he wants to do with it. But the status legally is simply called voidable because he has the choice now. She gave him an out. Does that make sense for everybody? Now, in the case of the one with the minor, we started from voidable right away because one of the parties could never be bound. But the most common way to get to voidable is actually start as valid and end up at voidable. Is it going to be very common in a real estate transaction that one of the two parties does not fulfill some small promise?
Yes.
All the time. Is it going to prevent us from closing? No, because ultimately Omar's going to have to decide, is it worth it to him not to close because of what? Steps on the deck. And what's he likely going to decide? I'll take it like it is. Because ultimately, and this is what your buyer clients will fail to understand, and this is what you have to impress upon them. Their only leverage in a transaction is to not what? Close. That's their only leverage. This is not preschool. Nobody is going to come in on wings on a mounted white horse and rescue you when one party doesn't do something they promised to do. Because here's what buyers want. I'm not picking on you on one, but I can tell you what the buyer's going to say to them. No, I want to close today, and then I want them to have to come back and fix these steps. Well, guess what, dumbass? When you buy it, they ain't coming back. Because you done what? You paid them. You gave them the money. They got no incentive to come back and fix a dadgum thing. And they're not going to. So you have to have a very real discussion with that buyer client and say, how important is it to you? Because the only way I can fight for you over these stairs is if you're willing to what? Walk away. And ultimately, most buyers just aren't. Does that make sense to you guys? And I'm not saying to be a jerk to your clients, but I'm saying you've got to have a real discussion with them. Because if they go close on that thing, you got no leverage left whatsoever. So usually when my buyers say, they got to fix this, I say, okay, how long are you willing to wait? Well, what do you mean? I mean exactly what I asked you. How long are you willing to wait? Because if you're telling me they have to fix it, that means I have to go back to them and say, we're not going to close until it's fixed. Well, we got closing in 2 hours. I said, I realize that. That's why I asked you the question. Because when you tell me they have to fix it, I'm telling you the result of that is going to be we're not closing today. And we're probably not closing tomorrow. And we're probably not closing the next day. Because if we're going to insist that they fix it, we're going to have to wait. We've already given them 2 months and they haven't fixed it yet. How long do you think it's going to take them to fix it? And then they're going to blow up. They can't do that. Sure they can. They can do whatever they want to do. Well, that ain't right. Well, your other recourse is to do what? Or go one step further than that. Take them to court and sue them. And guess what the buyer inevitably says to that? I'm not doing all that. So you see what I'm saying? A lot of buyers like to get real haughty about what they're going to do, what they can do. But ultimately, if you're not willing to sue somebody and you're not willing to walk away and not close, what are you going to end up having to do? Accept whatever they give you. That's the reality. Now, so I want you to understand these contractual words, but I want you to understand the real reality of the business. And that's why I say your job is to try to figure out a positive way forward. When that dispute comes up, I can tell you what I would do. I'm paying for some steps. I'm paying for some steps. Me, personally. Because if I'm representing that buyer, I'm going to look at him and say, you know what, they promised to do the steps aren't here, that is not right. What if we go ahead and close today and I'll get my contractor over here and fix the steps for you? Will that be okay? Is that not the most graceful way to diffuse that situation? And it might not be right, it might not be my responsibility, but I can tell you what, it's better than fighting over something that's probably not going to happen, and it's certainly better than not closing. You see what I mean? Yes, ma'am.
So they have the guaranteed right to delay, right? The buyer?
Everybody does, if you use a contract that has that built in. Or you're making the assumption that the contract has some right to delay built in. Contracts don't.
Okay.
Now, if you're talking about a specific contract, which is what I suspect you are, then yes, that could be built into a contract.
Okay, so, because they seem very similar, if they delay, does that make the contract voidable?
No.
If they're delaying under circumstances that...
If the contract gives them that right, it would only make the contract voidable to have a delay if the contract says you don't have a right to a delay.
Okay.
If the contract says you must close on this day, then a delay would be a breach.
Okay, so if it is built into the contract and they delay, it is still a valid contract?
That is correct, because they haven't violated the terms of the contract.
Right, okay.
It's a good question. Okay? Everybody understand what she's asking? She said, would a delay result in a voidable agreement? Well, that depends. How's the contract structured in the first place? If the contract says we have to close on this date, then would a delay be a breach? Yeah, absolutely it would.
How long
Well, that gets to the specifics of a certain contract. And that's the thing. And I'm going to tell you, it's going to be one of the hardest things you have to do on the test, is know when you're answering a generic contract law question versus a question that is specifically geared toward a certain contract, which we have not talked about yet. See, they're asking questions about a certain version of a specific sales contract and the things it has included in it. And that's great, but you got to know whether you're answering that question or you're answering a generic contract law question. Because right now we're talking about generic contract law. And so the answer to, does a delay make a contract voidable? Well, it depends. What does the contract say about a delay? Does that make sense? Okay. Do we understand voidable? How many parties are bound here? One. Valid is 2. Voidable is 1. Could we start as valid and end up at voidable? We could. You notice a trend here. We started with how many parties being bound? We went to, where do you think we headed? 0. Unenforceable. An unenforceable agreement. How many parties do you think this is enforceable on? 0. Nobody. It's an agreement. It's a set of promises. But it's not a set of promises that a court of law would do anything about. A court of law is going to look at it and say, this agreement is unenforceable. Neither party is bound by this agreement. Now it says it could start as valid. So let's go back to our example with Teresa and Omar. We said that they agreed that Teresa would sell her property to Omar for $200,000 and he agreed he would pay $200,000. And we said that was what kind of an agreement? It's a bilateral, but also what? Give me a valid agreement because it's enforceable against who? Both parties. I said furthermore, Teresa had agreed she would replace the deck steps as part of the agreement. And that's an enforceable promise. Additionally, Omar had agreed that he would allow Teresa to rent the property back after closing for 2 weeks. They're going to close, and he's going to rent the property to Teresa for 2 weeks after closing because she needs the money from the closing to buy her next house, and then she needs time to do what? To move. That's called a rent back. Make sense? Now, all of those promises are part of the contract. Is everybody following me on that? And what kind of contract did I say we had? A valid agreement. So all of those promises are enforceable. Does that make sense to everybody? So, click the wrong button. That's the button. Blank. There we go. So, we got a valid agreement with two parties. What was the first breach that I mentioned? What happened? Teresa didn't what? She didn't fix the steps. So it became what kind of a contract? Voidable. Because it went from being enforceable on how many parties? Two to enforceable on one. So now it's voidable. Omar gets pissed. Is he going to get mad about the steps? Yes. So here's what he said. Fine. You ain't replacing them steps. I'm not letting you rent the thing back. Not going to happen. Has Omar also breached the contract now? Yes. Two wrongs don't make a right in contract law, folks. So now tell me something. Which one of these parties has breached the contract? Both of them. So which one do you think a court of law is going to say, you have to follow this contract? Neither. What do you think we call that kind of a contract at that point in time? It's called what? Unenforceable. Because it's not enforceable, it can't be forced on either party because they both did what? They both breached it. That's unenforceable. Can't be enforced on either party. I'll tell you one other thing that you need to add to this slide. And it's probably the most likely example of an unenforceable contract they could give you on the test. Okay? You listening? Talk to me about the statute of frauds. The statute of frauds says certain legal documents must be what? In writing in order to be, what's that word? Enforceable. So if something was covered by the statute of frauds but wasn't in writing, it would be what? Unenforceable. A real estate sales contract is covered by the statute of frauds. So that means an oral real estate sales contract would be what? Unenforceable in a court of law. It would be an unenforceable agreement because the statute of fraud says that the only way that agreement can be enforceable is if it is in what? In writing. That is probably the most likely example you'll see of an unenforceable contract.
I think I remember from, I think one of the questions, was something about writing on a napkin.
Okay?
I don't know, I can't remember the whole, like, maybe that was a scenario where one was written on napkin, when the person was underage.
So talk to me. Written on a napkin. Real estate sales contract written on a napkin. What kind of contract is that likely going to be?
It's
Valid.
because both parties
Both parties agreed, and it's what?
in writing.
In writing. Don't care what it's written on. It'll be written on toilet paper. It's written, right? It'll be written on this table. Written. You might have to take the table to court and present it as evidence. It'd be kind of inconvenient, but it's written.
Okay,
How about the one where one of the parties was a minor?
that's not valid, that's
It's not valid, but what's the word for it?
voidable.
Voidable. Is everybody okay with that? Where one party is a minor, that means one party is not held responsible and one party is, the word for that is voidable. Okay? The word for when nobody is held responsible is what? Unenforceable. You good with that?
I got it
2,
wrong.
1, 0,
I got it
right?
wrong in text, but I remember.
You getting better now? And then the last one is void. Void really has nothing. Here's the thing. Do not think of voidable and void as being related. They are not related. I know they sound alike, but they're not related. Voidable and void are not related at all. Because voidable, remind me about voidable. It is what? A legally what? Enforceable agreement on at least what? One party. Void is not enforceable on anybody but for a very specific reason. It's a violation of the law. The promise was illegal from the very beginning. That's a void contract. A contract for an illegal act. Yuchan does not like her neighbor, and so she has put out a hit on them and have them killed. That is a void contract. It's a contract, it's a set of promises, but it can't be enforced because the promise that underlies it is what?
Wrong.
Illegal. That's void. Now, here's the thing. Void and unenforceable do not mean the same thing. Both of them are not enforceable. Does that make sense? But an unenforceable agreement is one where there's nothing wrong with the promises themselves, there's something wrong with the parties. The parties are making this agreement unenforceable. Whereas a void agreement means there's something wrong with the agreement. The actual agreement is all wrong. So you could have two legally competent parties that have a meeting of the mind with a contract that has consideration and it still be void. If what? They've promised to do what? What did they promise to do? It's void. What's it? Instantly, you should hear void, it should be illegal. They promised to do something that was illegal.
Using that in a real estate scenario, how would you best describe that other than like using a house for a crack house or something like that?
Bo has signed a written listing agreement with a seller of real property whereby they will pay him a 6% commission when their house sells. What's Bo's license status? He's sitting in the class with you. What's his license status? He's unlicensed. So him being paid a commission is what? Illegal. So that listing agreement would be what? Void, because the promise that's been made. So here's what we mean about that. Bo sells the property. They don't pay him. What's he going to try to do? Sue them. And when he goes to court, what's the judge going to say?
Where's your license?
Where's your license? This is an illegal promise. I can't enforce this agreement. This is a void contract. It never happened because the thing you promised to do in the first place was what? Illegal. Does that make sense? That's about the best one I can come up with from a real world real estate example. That's very different than unenforceable. Unenforceable, the judge would have to look at it and say, okay, the contract looks fine, so what's wrong with the people, right? Why are we unenforceable? Something would have to be wrong with the people. They've done something wrong, most likely, like not put it in writing. The agreement's fine, but you should have put it what? In writing. Yes, ma'am.
This is just conjecture, but say Bo started a transaction now.
Uh-huh.
Like I'm getting my license.
Mm-hmm.
By the time this closes, I'll be licensed.
Doesn't work. Because you said the magic word. He did what now? He started now. So he's being compensated for brokerage services that were rendered when he did not have an active license.
Right.
So it doesn't work.
So it started void, illegal, it's void from the start.
It's void from the beginning because he doesn't even have the right to make that agreement until he has a what? Until he has a real estate license. Until he has a real estate license. That's a void agreement. We feel okay about those? I know they are tough. The contract language is tough. And you're certainly going to see quite a few test questions about this because they know it's tough and they know you get tripped up on it. Here's what I want you, whenever you start having to differentiate between valid, voidable, void, and unenforceable, first thing you ask yourself, is it enforceable at all? Does that make sense? Because if it's enforceable at all, you're only left with two choices. What are they? Valid and voidable. If it has any legal strength at all, you're only left with valid and voidable. So then you ask yourself, is it enforceable on both sides, or does one side get out of this thing for free? If it's enforceable on both sides, it's what? Valid. And if one side gets out for free, it's what? Voidable. Now, if you ask yourself, does it have any legal weight at all, and you say no, then you can eliminate valid and voidable, and you're left with what two choices? Void and unenforceable. So then what's the next question you're going to ask yourself? What do you think? Is it legal or not? Because if it's illegal, which choice are you going to choose? Void. If it's legal but not enforceable, it is unenforceable. Does that help with kind of sorting them out?
Still, yes, but it's a long
It's tough. It is a tough process. I readily admit that. Contract law, this is a semester of law school right here. I mean, this chapter is a semester of law school because they spend an entire semester on basic contract law. They literally have 10, 12 hours worth of discussions about valid, void, voidable, and unenforceable. It's a very tough concept to wrap your brain around. And I've had attorneys that struggle with it even in the class. They're like, shit, I stuck to this when I was in law school. So it's tough for them too. We all right there? Can I move along with it? Okay. You're going to have to be able to differentiate those, so don't forget them. Make sure you come back to them. And this is where your question came from earlier. You talked about people being coerced. We have to have this reality of consent. And what that means is that we have to clearly show that the two parties do have an agreement with each other. So we can't have mistake. We can't have fraud or misrepresentation. We can't have duress, which I said was the threat of physical harm. So Christina signed a sales contract selling her family's farm because she was tied up in the back of a car. Is that under duress or is that undue influence? That is duress. That is the threat of physical harm. Undue influence would be if Christina's husband said he wanted a divorce unless she would sell the family farm. Because for undue influence, you have to have some type of an emotional connection with the person. It's preying on someone's emotions versus their physical health. No, different thing. She's had a bad day. Somebody had her locked up in the trunk, and her husband threatened to divorce her. So, both happened. Everybody okay with that? So if you have any of these present, like if somebody can go to court and prove, no, there was duress, I was under duress, then we don't have an enforceable agreement. What kind of agreement would that be? If Christina signed, here's a test for you. Let's say that Catherine makes an offer to purchase the property. And when Christina's real estate broker, her listing agent, presents it to her, Christina initially says no. Now the real estate broker needs the money badly. Grandmother would kill me if I used bad verbs. The real estate broker, Bud, needs the money terribly. And
That would be the truth.
Christina says no, and Bud pulls a knife out and says, "You won't accept this contract." And so Christina does the only rational thing, which is to what? Sign the contract. She signs it, she accepts it, Bud scans it and sends it back to the buyer. Everybody okay with that? Now, what kind of agreement do we have? Is it valid, void, voidable, or unenforceable? It is not void. What was illegal about the promise? The promise was to do what? Sell a property. There's nothing wrong with the promise. It is not void.
Illegal. You can't.
But that's not the promise. That has nothing to do with the promise. That's the problem. That's where you miss all these contract questions, because you start talking yourself down a rabbit hole. And then the Mad Hatter pops out and you fail. Okay? I'm telling you, that void means the thing that the two parties promised to do for each other was illegal. What did the two parties promise to do? Catherine had promised to do what?
Okay.
Pay money, and Christina promised to do what? Sell property. There's nothing illegal about that promise.
Oh, because the circumstances.
The circumstances absolutely impact the status of the contract, but they don't make the promise illegal. Does that make sense? It's not void because the promise is legal. So we've eliminated that. So now what are we left with? Valid, voidable, and unenforceable. Does that make sense? Is it valid? Are both parties going to be held responsible for their promises there? You think so? You think Christina, who was held at knife point to accept that contract, is going to be held legally responsible for it?
No.
Then don't say yes. Stop being dumb.
What is voidable?
Okay, so eliminate valid. So what are we left with? Voidable and unenforceable. So now, what does voidable mean? It's enforceable on how many people? One side. What does unenforceable mean? It's not enforceable on what? Either side. Is it enforceable on Catherine?
Yes.
Absolutely it is. She made her offer with no knowledge that any of that was good. Did she have anything to do with the knife being pulled on the other side? Did she know what she was promising to do? Absolutely. Has she made a very enforceable promise on that contract? And is she going to be bound by that promise? Yes. Has Christina made a legally enforceable promise? No. Because how did she make that promise? Under duress. So you have a contract where one side is bound and the other side is not. What kind of contract is that? That is a voidable contract. Catherine's bound, Christina's not. You see how you have to work your way through it? You have to work your way through it and ask yourself those detailed questions. It's a voidable contract. Could they close it still? Sure they could.
Because if she doesn't say anything and I put her at knife point, it's still valid.
It's not valid, it's voidable. It's voidable.
Nobody knows about it, it's not.
But again, that doesn't matter because nobody knows about it. This only matters if it ends up where. And that's again, you're down the rabbit hole. It is voidable. Because if it ended up in the one place where that would matter, which is where? In court, what would Christina say? Because how would it end up in court? Christina's going to try to back out, right? And who's going to sue her? The buyer is. Catherine, because Catherine has no idea this mess has happened on the other side. She's just looking at it from her perspective. I'm trying to buy the damn house. And I got a contract. It was signed by the seller, so why are they not selling it? Does that make sense? So what's she going to do? She's going to file a lawsuit. And then when Christina walks into court, what's her testimony going to be? I did sign that contract, but my real estate broker was holding me at knife point when I did. And the judge is probably going to say we have a voidable contract. And so then the judge is going to look at Christina and say, ma'am, what do you want to do with this contract? Do you want to follow through with it? Because can she still follow through with it? Sure. Do you want to follow through with it? Or do you want to terminate it? It's going to be her choice because it's voidable. Is he going to look at Catherine and give her any choice? No, because it's enforceable on her side. Does that make sense? That's a voidable contract. That is a voidable contract.
So she could probably say, well, not probably, she could say, yes, I want to go through it, but I want him locked up.
Yeah, most likely. I mean, she could, certainly. She could have, but she's probably not going to want to go through with it because the whole reason she got held at knife point in the first place was she wouldn't what? She didn't want to sell. She didn't want to agree to it. Is everybody okay with that? I get that they're tough. You make them tougher than they have to be by refusing to work through a progression with it. I always start with just a very basic question. Does it have any legal force whatsoever? Are either of these two people bound? And that just simply means look at each side individually. From Christina's side, clearly something went wrong. Is that clear? But from Catherine's side, was there any problem? No. So that means from Catherine's side, there's probably some legal force in play. Everybody okay with that? All right. You'll see bunches of those on the test. Not bunches, but you'll see more than one, most likely. Okay? That's going to be a good place, I think, to take a break, because when we come back, we want to talk about the idea of offer and acceptance and how we actually put something under contract and when it actually is under contract. So let's go ahead and take your lunch break and be back at, just say 1:15. 1:15, okay?
Is midterms going to be the homework for us?
You're going to get